Hello, listeners, and welcome to Privacy Chats with Rachel and John, a podcast for privacy professionals and enthusiasts alike. I'm Rachel.
And I'm John. We're your hosts. We'll be sharing our perspective on privacy and the U.S. Constitution. But before we get into the episode, I just want to share that the information shared throughout this episode is our own, and it's not in any way affiliated with our employers or any other organizations. These episodes are produced on our own time and are based on our own research and some of our professional opinions.
So, John, we have talked about several different laws and regulations about privacy, but why do you want to talk about the U.S. Constitution?
Well, I mean, first of all, I was taking a class recently that's about the U.S. Constitution. I'll talk a little bit more about that, but that was the inspiration for me. And really, as important as privacy is to both of us, because we talk about it a lot, it's very specifically not called out in the Constitution. And if I could go back in time and talk to influence the authors of the Constitution, that's one of the top recommendations that I would offer to them, is to include a provision that recognizes privacy as a fundamental right. I think they just assumed it, so they didn't write it in there.
Yeah, maybe we can give them a telescope that can see 400 years into the future. How about that?
Maybe, yes. Lots of change, lots of advice we would offer them, right?
Seriously. Well, if the Constitution doesn't address privacy, it sounds like this might be a short episode. And it's funny you actually bring up the Constitution here, because I spoke to a class at ASU and asked the question of, it was a teaser for asking them if why privacy law actually existed in this country. And they said, no, but we have the Fourth Amendment. And I said, you're not wrong, but I guess we'll get into a little bit of that later. What is the connection to privacy, John?
So, it's there. So privacy isn't explicitly called out, but there is a long history of recognizing that people have a right to privacy, and that right can be inferred from several amendments in the Constitution. And I genuinely think that the authors of the Constitution intended it. Like, I think that they believed it as such a fundamental right, and it wasn't necessary to write it. So it's there.
It's implied almost in the verbiage they use, but maybe not saying the word, the P word.
They just didn't use the word, right? Exactly.
Gosh darn it. Well, we have mentioned the Fourth Amendment, right, which protects citizens, you and I, against unreasonable searches and seizures by the government. And
Right.
Protecting us, means our effects, our houses, our things. And if I could add my 2 cents to hear why privacy gets that connotation of being related to the Fourth Amendment, it's probably because it's extrapolating actually the second half of, what the full verbiage or language of the Fourth Amendment is. And I won't bore anyone here. You can look it up. But kind of like there's the first half that says, hey, we're promising a right to, secure your effects, your house, your things, whatever.
Sure.
But then you're characterizing what you're actually protecting that against, with the implication of unreasonable searches and seizures being that thing that we don't want, right? That attribution to privacy comes from that second part where would we expect that violation to occur, and how does that happen? I think over time, it's very fair to bucket in where we are in our current society and how we interact, and just the digital nature of it, to describe, scenarios that didn't exist when the Constitution was written, to your point of wanting to go back in time and tap, the framers on the shoulder. We were far less connected hundreds of years ago. We were so spread out. These opportunities for intrusion just looked so fundamentally different than they are in our society today. So yeah, that's what I have to say about what I understand about the Fourth Amendment being related to privacy. But how about you, John?
Yeah. Well, I mean, it's true. The Fourth Amendment also very specifically doesn't use the word privacy, but it's very specifically protecting against the state just entering your house with a clear protection of a person's right to privacy within their home. So, that's given. And, so you have to kind of think about what else does privacy extend to? If you have the right to privacy within your home, do you have a right to privacy in other things? And I think that's where we're going to get to.
Yeah, I don't know if we mentioned the castle doctrine in the past. I wouldn't be surprised if we did, because we love to look at old English law in this podcast, I guess. But I mean, that comes from colonial times, where colonists were sick of the general warrants just pulling up to their house and just searching indiscriminately, so to speak. And that they didn't need to specify necessarily why, which is alarming to me, putting myself in those shoes. But that's how we got here in the first place with the Fourth Amendment. So I do see that relationship, but again, it extends so much more, I think, than our homes right now, given the information that's out there that would really describe what we're doing in our private and free time.
Yeah, agreed. And there's a lot of that Old English law you can find throughout the laws and customs and practices and stuff that we have across our own country. So but there's let's go back into like what's the I guess the fundamental structure of all of this. So the foundation of where our laws come from is the Constitution itself. It's the supreme law of the land. It takes precedent over all federal, state, and local laws that might be passed. And the Supreme Court, very specifically, is the authority itself that decides if laws are consistent with the Constitution. And I mentioned that I'm taking a class in constitutional law.
Yeah, so you are the expert here today.
Oh dear, please. Okay, maybe compared to you, but I don't feel like an expert in constitutional law at all. So please don't at me
Complex.
if you're listening to this. But it was interesting. They in the class we went into an 1803 case of a Marbury versus Madison, where this was established, and it's interesting because we think of the Constitution as being foundational. We don't doubt it, or like who has authority. Obviously, the Supreme Court has authority, but in 1803, that norm wasn't really established yet. So the Supreme Court had to establish itself as the authority. And it cited the Constitution itself in that case, stating that the Constitution vests the whole judicial power of the United States in one Supreme Court, and such inferior courts as the Congress shall from time to time ordain and establish. And in the final holding in that case of Marbury versus Madison, the court held that a law repugnant to the Constitution is void, that all courts as well as other departments are bound by the instrument. So that kind of established that foundational principle that the Constitution is it. That's the be all and end all of laws in the country.
Yeah. I wish more people could, appreciate that level of specificity when we talk about politics, when we talk about the United States. And I can't say, it's really the fault of the receivers of our education system. I certainly wasn't pleased with how the lack of detail and the lack of emphasis, I think it was put in my generation as opposed to prior, but I digress. I've always appreciated that the role of the Constitution is to evaluate laws and to interpret the Constitution and determine whether those laws in the way that they were passed by Congress, can be complied with. So what else do we have to cover today?
So, the first actual case that I went in that I want to talk about is a 1965 case of Griswold versus Connecticut. And I think you and I have actually talked about this law or this case one time, a long time ago, about the history of privacy or something. But this was an appeal of a conviction of a married couple for violating what was a statute in the state of Connecticut at the time that prohibited, and this is a quote from the law, the dispensing or use of birth control devices to or by married couples. So at that time in 1965 in Connecticut, you couldn't use contraceptives.
So this established the right for people to use contraception then, essentially.
Yes. And since the Constitution is the law of the land, this, ruling applied everywhere. So essentially the court in Griswold found that this right to privacy was found throughout the Constitution. So they very specifically went through different parts of the Constitution itself and said there's rights to privacy in here. And they cited the First Amendment, which is the right of association, the Third Amendment, which is prohibition against quartering of soldiers in any house in time of peace without the owner's consent. So kind of go back to the castle doctrine that you talked about.
Mm-hmm.
The Fourth Amendment, which is a right against unreasonable searches and seizures, which you already talked about. The Fifth Amendment, which is a provision against self-incrimination. So I've got that right to privacy. You can't make me incriminate myself. And then it also cited the Ninth Amendment, which basically, I'll quote this. It says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So basically it's saying that, you have these other rights, and just because it's not enumerated in the Constitution doesn't mean they don't exist.
Right. So then it kind of sounds like picking two of those out. We have two amendments that are about protecting, homes or property to a certain extent. And I have to, kind of pull back on that Third Amendment being also from something the colonists didn't like, which was being forced to surrender their homes to British soldiers, the Quartering Act of 1774. Another thought came up though, just while you were going through the few amendments you were talking about here, which is the relationship between privacy and interference and how that relates to the
Yeah.
Constitution. I think and again, this is out of my own brain, this is just my own inclination, but
Yeah.
privacy has to do with, right, interference, or, in the more technical ways, decisional interference. And privacy has a relationship with knowledge and information. And if you have an entity that wants to, say, authoritate what you are doing, they
Yeah.
must know what you are doing, right? So then you start encroaching
Okay.
in that, and that's where I see the relationship throughout the entire Constitution of there are limits to what can be encroached to understand more about you, or figure out what you're doing, or control your actions in some way with more information. I think that's where I see the relationship throughout these amendments that we're mentioning here.
Yeah, agreed. And like some of the things that we talked about, and very specifically in these amendments, is a right to have control of your own property. So, and you
Mhm.
talked about the castle doctrine. But I just can't believe that the framers of the Constitution would emphasize this right to protect your property without also believing that you have a right to control of other things, very specifically yourself. Like,
Yeah.
do I have rights to control my property and not have rights to control myself?
Mhm.
Or by an extension of that, information about yourself. So, and that's where I think it just wasn't explicitly stated, because they thought it was such a fundamental right that they didn't need to write it down.
Yeah, it was
And
a
I
no-brainer.
just wish it was a no-brainer, but here we are, needing for it to be. I mean, I guess there's plenty of people with no brains, perhaps.
Very true. Well, it sounds like, Warner Brandy's, with their right to privacy doctrine, had identified this, and we're ahead of their time in that way.
Yeah, agreed. I mean, good segue. We've talked about that right to privacy article in the Harvard Law Review,
Mhm.
which kind of set the framework or the foundations of the rights to privacy. Um, so let's move on. So following Griswold, so I said that it was 1964, 66 somewhere was Griswold. There was a lot of other cases that were about the right to privacy. And the most controversial one is Roe versus Wade in 1974. Very, very famous Supreme Court ruling. But it specifically cited Griswold and recognizes that women have a right to control of their own bodies. But it also kind of uh, created this balance because it created limits to when the laws may prohibit abortions, and it set up a different restrictions for each trimester. So this trimester approach essentially balanced the women's right to her own body with the emerging rights of the growing human within her. So at some point, a baby is going to be born, and that baby is going to have rights. At what point in time do
Right.
those rights start to exist? And I think Roe versus Wade did a good job of balancing the rights of the woman who's carrying the baby against the rights of the baby
Absolutely.
themselves.
Yeah, because the wrong situations, you have health risks. But I also recognize that, people have certain assertions and opinions about, when life is considered life. And it's a tough thing to define. However, I will mention that, as my understanding, Roe v. Wade was struck down by the Supreme Court 2022, despite mountains of data that I had perceived suggesting that this was, in the interest of the people, or it was actually against the interests of the people. I'm saying that backwards, but
Mhm.
I was very surprised to see that, because that is not, I don't know, a lot of states have a lot of different styles, a lot of different leaders, a lot of different representatives, and
Yeah.
I think that access was important from a health standpoint. I wish to not see that removed, but that is a personal assertion, just as a disclaimer.
Yeah. Well, I mean, I'll go fully on record and say I fully agree with you. I think that overturning Roe versus Wade was the wrong thing for the court to have done. I think that it was a political move. When Donald Trump came into office, he signaled that he intended to overturn Roe versus Wade, and he achieved that by appointing the right people to the Supreme Court. I think it was a political move. It was overturned. You're right. It was 2022. The case was Dobbs versus Jackson Women's Health Organization.
Mouthful.
Um, it is a mouthful, but yeah, I think it was a political move for sure.
Yeah. And I will recognize it's not that abortion was outlawed across the nation. The Supreme
Correct.
Court just said that the U.S. Constitution doesn't have much to say, which is kind of roundabout to me. But that the states can, decide whether they want to restrict abortion, in what nature to do so, so long as their laws that they're making and have that legitimate purpose specified. I'd imagine that this comes with a religious agenda in some states that might have something to do with decisions that crop up over the next few years and that have already done so in the past. But it doesn't sit right with me. It feels like we're trending in a direction I didn't see this country going in.
Yeah, and I don't think it's going to stand. I think that Dobbs will eventually be overturned in itself, but I also don't like to see the Supreme Court flip-flopping back and forth like that.
Mhm.
I mean, it's one thing for them to flip and then flop, but if it's going to be just a back and forth, that's not right.
Yeah.
But signaling the fact that I think it was is a political thing, as part of the opinion that was written in Dobbs. The majority wrote, and this is a quote from that said that nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. So basically, they wanted to retain all precedents, including Griswold about the rights to privacy, but
Mhm.
deny just the abortion part itself. And that's just not how I see the Supreme Court working. That's not how the Constitution works. You can't just say, yes, everything about this can
I like
stand,
these and not
except for,
these.
right, just this one very, very narrow case doesn't work for us. And so, it was they were trying to overturn that one thing without recognizing the broader picture of privacy and a woman having the right to control her own body.
Right.
And they just said, I just don't want women doing that one thing with their body.
Yeah, which seems very nitpicky, and it causes me to lose a little bit of faith that we have in our judges and elected representatives at the moment. But I digress. What else do you have for us? Lighten
So
up.
there was a few other cases that I thought were very interesting related to privacy. So there was one, Loving versus Virginia in 1967, struck down a Virginia statute that made it a crime for a white person to marry outside of the Caucasian race. Um, and which is stunning to me. 1967
This is
isn't
wild.
it's
Wasn't
yeah,
that
that's
long
not
ago.
too it's not it's I mean it's just a few years before I was born. So, and who to marry is clearly a very private and intimate decision that frankly is none of the state's business.
Yeah.
It's not so there's another case I want to talk about is Brown versus Board of Education. This isn't specifically about privacy, but I want to talk about it anyway because I
Yeah.
think it was very important ruling in the court. So this happened in 1954. That invoked the Equal Protection Clause to strike down a previous ruling from Plessy versus Ferguson, which established the separate equal approach that was anything but equal for people in this country. But pointing out that the necessity of that and the court doing something like that, there was a follow-up case to Brown. It was called Griffin versus the School Board of Prince Edward County in Virginia in 1966. That in response to Brown, the public school board was so resistant to racial integration that they attempted to actually close all of their public schools and pay for their children to attend racially segregated private schools. So when you think that what Brown accomplished was huge, but that was the society that they were fighting against, was like a county actually was willing to shut down all of their schools and pay for students to attend private schools because private schools, they believed at the time, could still be segregated, which is obviously no longer true today.
Yeah. Seems like a lot of hoopla for very little impact, but
Just
again,
a lot of hatred.
yeah, it is.
Right.
It is all disturbing to think in retrospect, which is, I guess, a good sign of the progress we've made today. And
Agreed.
it's just not the fact that it wasn't that long ago begs me to think that some of these values are still around today.
Yeah.
I just can't imagine where a world where I would live in a country that had a law, again, anywhere that would have prevented me from marrying my partner. It's just
Yeah.
that was a case worth being thankful for, as well as a lot of others you've mentioned here. But let's go back to privacy.
So yeah, so talking about marrying who you want to marry, there's a couple of other cases that I want to talk about. The Supreme Court ruled in one case. The first one I want to talk about is Bowers versus Hardwick in 1986. So again, not too long ago.
Creeping up, yep.
So that one upheld a Georgia sodomy statute, ruling that the right to privacy does not protect a right to engage in private consensual homosexual activity. And interestingly, if you read the opinion, the court in this case was relying on its moral judgment. So it wasn't looking at the Constitution itself, it was looking at its moral judgment, enforcing the Constitution. Actually, this is a quote from that, citing a belief of a majority of the electorate in Georgia that homosexual sodomy is immoral and unacceptable. Well, something being immoral and unacceptable has really nothing to do with the Constitution.
Yeah,
So
that's
basically, they were
individual judgment, individual opinion. You know, we settle on
right.
very fundamental rights. The right to
Yeah.
choose, I believe, is one of those.
Absolutely. So thankfully, 17 years later, there was a different case about the same topic. The case was Lawrence versus Texas that came before the court, which was also about private, consensual, intimate contact between people of the same gender. But this time, the court, instead of focusing on the morality of it or how people in Georgia felt, or Texas, I guess, they focused on the constitutional protections afforded to people, and they reversed Bowers, which struck down many laws across the country which deemed homosexual activity criminal, but that only happened in the early 2000s.
Yeah, that, I mean, it's finally a few years after I'm born, right?
Yeah.
It is fascinating to think, you know, that these were such big issues. And I mean, in a lot of ways, we are still coming to an understanding of what we need in this country for the people that are in it. And
Yeah.
I'm happy to see the progress. I am also interested to hear more cases if you have time.
So there's a couple. There's another category that went into which gets into medicine and laws about an end of life care, which is kind of sad. Um, so let's jump into some of these real quick. So the first one is Washington versus Harper in 1990 established that prisoners have the right to be free from involuntary administration of antipsychotic drugs, which of course they should have that right. But it wasn't until 1990 that the courts recognized that they should have that right.
Yeah.
There was another case the same year in 1990, Cruzan versus the director of the Missouri Department of Health established a right to refuse medical treatment. And this one was interesting because it was very specifically included life-sustaining nutrition. And it stated in their opinion that for the purposes of this case, we assume that the United States Constitution would grant a competent person a right to refuse life-sustaining hydration and nutrition. So as a free person who has the right to privacy, I can control what goes on with my own body. I can choose to refrain from nutrition, hydration, whatever it is that's going to keep me alive. So
Very fascinating. I mean, these are so interesting because they kind of toggle between the right to decide against something and the right to opt into something. Now, all of those things being related to individual choice, but it is
yeah.
responding to, you know, larger entities' assumption of what should be and should not be allowed to be made by choice and what should be default.
Yeah, agreed. And obviously that, that right to refrain from life-sustaining hydration and nutrition is essentially tantamount to suicide. But there's a subtle nuance there that I'm not actually committing suicide. I'm just refraining from taking the things that prevent me from living, right? So a couple of the cases in 1997, Washington versus Glucksberg and Vacco versus Quill, rejected that people have a right to physician-assisted suicide. And in that case, they cited that rights can only be protected when there's a history or tradition in our country. And the court actually went back and stated that for over 700 years, the Anglo-American common law tradition has punished or otherwise disapproved of both suicide and attempting suicide. So the right to suicide doesn't exist today still. But in recognizing that, the history of our country and our culture is that suicide is wrong. It shouldn't be allowed. So there's a like a nuance between
The
I
last
can
case in this
not eat and
case
drink, but
are so small, so
yeah.
similar, but just different enough.
So this one's a little bit different. It was 1977. A case is Whalen versus Roe. I'm totally assuming it's a different Roe than Roe v. Wade.
Yeah.
But
ironic.
This one upheld a New York law requiring that physicians provide reports identifying patients who receive prescriptions for drugs that have a potential for abuse. Which interestingly, in 1977, essentially carved out an exception to privacy for health records, which we all take for granted because of the HIPAA regulations, which were, I think, 1996, if I remember correctly.
Yeah, you're right.
So basically, there's a lot of case law on the books that recognize that there is a constitutional right to privacy, even though, like we said in the beginning, it's not explicitly called out in the Constitution.
I didn't know about that, the New York law one. That was very interesting. I'd never heard, kind of a, I don't want to say a contradiction, but kind of a principle that is a little bit, coinciding with HIPAA in the way of protecting health records. But
It's
uh go ahead.
I was just going to respond to that. I'm trying to remember if HIPAA has a provision in it about recognizing old laws that are already on the book. So
Right?
I
It's
think
kind of
that
where my
I
mind's
think that
going
it
too.
did. Yeah, but it actually makes sense that
Mhm.
we want to control prescription drugs or narcotics and stuff like
Yeah,
that. So the fact that law enforcement agencies would have access to records of who's getting prescription drugs makes sense to me. I think
right.
that's an appropriate carve out from HIPAA.
Yeah, absolutely. So let's wrap things up. Any final thoughts with all the cases you've shared today? I know I've been interjecting with my thoughts and opinions, but I'm ready to listen
No,
to yours.
no, it's been great. I think that's kind of it. Through we've established in our, whatever number of episodes that we've done through this podcast that we are absolute supporters of privacy. And, like I said in the beginning, I wish that was explicit in the Constitution, but thankfully the Supreme Court has been pretty consistently, except for the Dobbs thing, but they've been pretty consistently supportive of recognizing that the right to privacy can be easily inferred from the text of the Constitution. So, if the court is recognizing that it's there in most cases, then I guess that's going to have to be good enough because I actually can't go back and talk to the framers of the Constitution.
You don't have a time capsule? Can you
Well,
squeeze into
I
and press a
have
button?
I have my TARDIS here. Does that count?
That's like the same thing. You can fit in there, right?
There
For
you
those
go.
that
Exactly.
can see, it is about what, 5 inches tall,
That's right.
3 inches
Yeah,
wide.
it's
Oh,
bigger
and
on the inside.
yeah, yeah. Well, I'm happy to see what you return back with and
Okay,
report. But
stay
um
tuned.
until next time, thank you for tuning into this episode of Privacy Chats with Rachel and John. You can find the links to all the articles we mentioned, especially the ones with the longer names, if you didn't catch them right away, in the episode description for your reading later on. Don't forget to check out our LinkedIn page where you can keep up to date on our latest episode releases. Thanks, John.
Thanks, Rachel. See you next time.